Module 3. Types of evidence. Understanding the types of evidence. Evidence is the cornerstone of reasoning, decision-making, and argumentation in various contexts, from legal proceedings to scientific research and academic writing. The types of evidence employed significantly influence a claim's strength, credibility, and persuasiveness. Understanding these types of evidence helps in effectively crafting arguments, evaluating information, and making informed judgments. One key type of evidence is empirical evidence derived from observation, experimentation, or measurable phenomena. Empirical evidence is foundational in scientific inquiry, where hypotheses are tested against observable data to validate theories. For example, researchers in a laboratory setting may gather quantitative data through controlled experiments or collect qualitative data through field studies. This type of evidence is valued for its ability to provide objective insights, though it may still require interpretation to connect findings to broader claims. Another essential type of evidence is anecdotal evidence, which relies on personal experiences or specific instances to illustrate a point. This type of evidence often appeals to an audience's emotions or relatable aspects, making it particularly effective in persuasive contexts such as storytelling, journalism, or advocacy. While anecdotal evidence can be compelling, it lacks the generalizability of empirical evidence and may not provide a comprehensive view of an issue. Nevertheless, it often serves as a powerful complement to other forms of evidence by humanizing abstract ideas or data. Testimonial evidence comes from the statements or expertise of individuals considered authoritative or knowledgeable in a specific field. This type of evidence can bolster an argument by lending credibility through the voice of an expert or a witness. For instance, a medical professional's endorsement of a treatment or a historian's account of a historical event can be persuasive due to their perceived authority. However, the reliability of testimonial evidence depends heavily on the credentials and impartiality of the source. Documentary evidence encompasses written, visual, or recorded materials that serve as records supporting a claim. This includes books, articles, contracts, photographs, videos, and other forms of documentation. Documentary evidence often includes contracts, emails, or other written agreements in legal contexts. In academic and professional settings, correctly cited references to credible sources ensure that arguments are rooted in established knowledge. While documentary evidence provides concrete support, its interpretation can sometimes be contested, depending on the creator's context or intent. Logical evidence involves reasoning and using facts to construct a coherent argument. It is often used with other types of evidence to create a sound basis for conclusions. Logical evidence is particularly significant in philosophy, mathematics, and disciplines where abstract reasoning is central. This evidence relies on identifying patterns, drawing inferences, and demonstrating causality, making it a critical tool for complex problem-solving. The role and purpose of opening statements in a trial. Opening statements mark the beginning of the evidentiary phase of a trial, providing each party an opportunity to outline their case and set the tone for the proceedings. While not evidence, these statements serve as a roadmap, helping jurors or the judge understand the narrative and key points each side intends to prove. Delivered by the attorneys for both the plaintiff and the defendant in a civil trial, or the prosecution and defense in a criminal trial, opening statements are structured to present a clear, concise, and compelling overview of the facts and anticipated evidence. The primary purpose of opening statements is to establish credibility and engage the decision-makers in the legal process. Attorneys use this moment to highlight the core themes of their case, such as justice, responsibility, or fairness, and to contextualize the evidence and testimony they will present. They may emphasize critical facts and suggest how the evidence will support their claims. Still, they must refrain from arguments or inflammatory language, as the opening statement is not the time to persuade, but to inform. An effective opening statement weaves a logical and relatable narrative, making complex legal issues accessible to the jury or judge. It also anticipates and subtly addresses potential weaknesses in the case, aiming to mitigate their impact before the opposing side can exploit them. Opening statements guide the trial's progression by setting the stage with clarity and confidence, influencing how the evidence and testimony are perceived. The boundaries of evidence in opening statements. Opening statements are critical in setting the tone and direction for a trial, providing the jury with a roadmap of the case. However, they are only an opportunity for attorneys to present some evidence or delve into arguments. Instead, opening statements outline the proof introduced during the trial while adhering to strict legal and procedural boundaries. The prohibition against mentioning certain types of evidence during this phase safeguards the trial's fairness and integrity, ensuring that only admissible and relevant information influences the jury. Evidence inadmissible under the rules of evidence cannot be mentioned during an opening statement. For example, hearsay is prohibited unless it falls under a recognized exception. Similarly, character evidence, which aims to prove that a person acted in conformity with a particular character trait, is generally barred unless it directly pertains to the case. Attorneys must also refrain from referencing evidence that is ruled admissible. Introducing such evidence prematurely risks influencing the jury before its reliability or relevance has been established. Statements about speculative or hypothetical evidence are equally inappropriate. For instance, referencing evidence that may arise later in the trial but is not sure to be admitted can mislead the jury and undermine the opposing party's right to a fair trial. Additionally, evidence that violates legal privileges, such as attorney-client communications, must remain outside the scope of an opening statement. Understanding direct evidence. Definition and explanation. Direct evidence is a fundamental concept in the legal and investigative fields, playing a pivotal role in determining the truth of a matter. It refers to evidence directly linking a fact to the issue without requiring inference or presumption. Unlike circumstantial evidence, which relies on a series of deductions to establish a connection, direct evidence explicitly demonstrates the fact. The defining characteristic of direct evidence is its straightforwardness. This evidence provides a clear and immediate connection between the event or fact and the evidence itself. Examples often include eyewitness testimony, audio or video recordings of an incident, or confessions. For instance, if a witness testifies that they saw a person commit a crime, this constitutes direct evidence. The reliability of such evidence often rests on the source's credibility and the absence of contradictions. Direct evidence is valued for simplifying judicial processes by eliminating the need for complex reasoning to establish a fact. However, its strength depends significantly on the quality and context of the evidence provided. An eyewitness account may be considered direct evidence, but its persuasiveness can be diminished by factors such as poor visibility, biased perception, or the witness's questionable integrity. Similarly, recorded evidence must be authenticated to ensure it has not been tampered with or misrepresented. Understanding inferences and the role of direct evidence in proving facts. Inferences and direct evidence play distinct yet interconnected roles in understanding and establishing facts. An inference is a logical conclusion drawn from available information, often filling gaps where direct observation or concrete proof is absent. It involves reasoning based on context, patterns, or related data, allowing individuals to form beliefs or judgments about events or phenomena. For example, seeing wet pavement might lead someone to infer that it rained, even if they did not witness the rainfall directly. While inferences are valuable for making sense of incomplete information, they rely on assumptions and are not definitive proof. Direct evidence, by contrast, is a form of proof that explicitly establishes a fact without requiring inference. It is tangible and observable, connecting directly to the point in question. Examples include eyewitness testimony, video recordings, or physical objects like a signed contract. This evidence provides an unambiguous link between an event and its verification, If a person sees rain falling, their testimony of witnessing the rainfall constitutes direct evidence. Unlike inferential reasoning, which requires interpretation, direct evidence speaks for itself and leaves little room for ambiguity or doubt. Understanding the two types of real evidence. Objective evidence is pivotal in substantiating claims and establishing facts in legal and investigative contexts. Objective evidence refers to tangible, physical objects presented in court to prove or disprove specific facts in a case. It serves as direct proof, requiring no additional explanation or testimony to establish its existence or relevance. This form of evidence is classified into two distinct types: physical and demonstrative. Physical evidence includes any tangible object directly associated with the case under investigation. It is an actual, material item that can be touched or inspected and serves as a silent witness to an event. Physical evidence includes a weapon used in a crime, a piece of clothing from a victim, or a document bearing a suspect's signature. The critical characteristic of physical evidence is its inherent ability to connect a person, place, or event to a specific occurrence, often through forensic analysis or expert examination. On the other hand, demonstrative evidence is created to represent or illustrate a fact or condition relevant to the case. This evidence is not directly involved in the incident, but is produced to clarify or provide context for physical or testimonial evidence. Common examples in diagrams, maps, models, photographs, or videos that help to reconstruct a scene or explain complex processes. Demonstrative evidence makes abstract or technical information more understandable to judges or juries. The importance of relevance in evidence. Evidence plays a critical role in legal proceedings, serving as the foundation upon which cases are built and decisions are made. For evidence to be admissible, it must be relevant. Relevance is the quality of evidence that makes a fact at issue in a case more or less likely to be true. This concept ensures that only material that genuinely impacts the determination of the case is presented, preventing the court from being misled or distracted by irrelevant or prejudicial information. Relevance connects the evidence to the issues in dispute. If a fact does not affect the outcome, presenting it wastes time and may need clarification for the decision-makers. For instance, in a personal injury case, evidence about the injured party's driving record may be irrelevant unless the case involves the party's driving habits at the time of the accident. Such an example highlights the precision required to determine whether evidence directly affects the matters under consideration. Understanding the concept of a hostile witness in legal proceedings. In legal contexts, a hostile witness refers to an individual called to testify by one party who exhibits antagonism or resistance to the questioning. This witness may provide testimony adverse to the interests of the party that summoned them, creating a challenge in presenting a cohesive case. The designation of a witness as hostile typically arises during cross-examination when it becomes apparent that the witness's responses are uncooperative and potentially detrimental to the examining party's objectives. The status of a hostile witness must be established through a formal request to the judge, who assesses the witness's behavior and demeanor. Once deemed hostile, the party calling the witness may ask leading questions otherwise prohibited during direct examination. These questions allow the examiner to steer the witness's testimony to clarify or counteract damaging statements. This exception to standard examination rules underscores the unique nature of a hostile witness in judicial proceedings. The role and impact of leading questions in court. Leading questions play a significant role in courtroom proceedings, often sparking debate over their appropriateness and influence. A leading question suggests its answer or directs the respondent toward a specific response. These questions are most commonly framed in a way that subtly or overtly guides the witness to confirm or align with the questioner's narrative. For instance, instead of asking an open-ended query such as, "What happened next?" a leading question might ask, "You saw the defendant holding the knife, didn't you?" Leading questions are tightly regulated within the legal system, as their improper application can distort the truth-seeking process. During direct examination, when a lawyer questions their witness, leading questions are generally prohibited to ensure that the witness's testimony is based on their recollection rather than the attorney's influence. However, they are typically permitted during cross-examination, where the goal is to challenge or test the credibility of the opposing party's witness. The concern with leading questions lies in their potential to manipulate or bias testimony. When a witness is subtly directed toward a specific answer, their response may reflect the pressure of the question rather than their recollection. Courts aim to balance the need for efficient questioning with the fundamental objective of obtaining reliable and unbiased testimony. By carefully regulating leading questions, the legal system seeks to preserve the integrity of the judicial process and uphold the principle of fairness in the pursuit of justice. The permissibility of leading questions for hostile witnesses. In legal proceedings, examining witnesses is crucial in uncovering facts and establishing truth. The use of leading questions when discussing a hostile witness is a distinct and significant exception to the general questioning rules. Leading questions are typically prohibited during direct examination to ensure the testimony is given freely and reflects the witness's account. However, when a witness is declared hostile, leading questions become permissible to elicit reliable information. By definition, a hostile witness demonstrates adversarial behavior, such as being uncooperative, evasive, or outright oppositional to the party who called them. Their conduct may obstruct the fair presentation of evidence, necessitating a more direct approach. Leading questions suggest the answer within the question itself, enabling the examining attorney to regain control of the narrative and guide the witness toward addressing specific facts. This technique ensures clarity and precision in testimony, particularly when a witness may attempt to obscure or avoid the truth. Understanding the concept of facts, not in evidence. The phrase, facts not in evidence, is a foundational principle in legal and critical reasoning, underscoring the need for assertions to be supported by concrete proof. This concept safeguards against speculative arguments and unverified claims in courtroom proceedings, ensuring that decisions are based on admissible evidence rather than conjecture. Facts not in evidence are statements or assumptions introduced without proper substantiation through witness testimony, documentation, or other permissible means. When such claims are made, opposing counsel may object, emphasizing the importance of verifiable truth in deliberations. This principle extends beyond the legal system into everyday discourse and academic inquiry. Supported assertions can lead to flawed reasoning and incorrect conclusions in debates, policymaking, and scientific exploration. Critical thinking requires careful examination of the sources and credibility of the information presented. With a reliance on evidence, arguments can be dismissed as opinion or hearsay, undermining their validity. Navigating objections to questions assuming facts not in evidence. In litigation, an objection that a question assumes facts not in evidence challenges the inquiry's decency and the trial process's fairness. When this objection is raised, the questioning attorney must promptly and strategically address the concern while advancing their case. Such objections highlight that attorneys may not present information through questions not formally introduced or established through admissible evidence. First, the questioning attorney must decide whether to defend or reformulate the question. If the objection is valid, the attorney should revise the question to avoid incorporating unproven assertions. This may involve neutrally rephrasing the question, allowing the witness to provide the necessary foundation without presuppositions. Alternatively, if the attorney believes the objection is unfounded, they may articulate why the question is appropriate. This could involve pointing out evidence already admitted that substantiates the facts referenced in the question. Another avenue is laying the necessary foundation by presenting admissible evidence or testimony to establish the facts. This step, however, requires the questioning attorney to recognize when and how to pivot their strategy to address the objection and proceed effectively. Establishing the factual predicate before revisiting the challenged question ensures compliance with evidentiary rules and protects the integrity of the examination. Finally, the attorney must maintain a composed demeanor. Responses to objections, particularly before a judge or jury, should reflect professionalism and confidence. Engaging in unnecessary arguments or appearing unprepared can detract from the attorney's credibility. By adapting to the objection while remaining committed to the case's goals, the questioning attorney demonstrates legal understanding and the ability to navigate the intricate dynamics of trial advocacy. The nature and role of circumstantial evidence. Circumstantial evidence, a cornerstone of legal reasoning, refers to information and facts that suggest a conclusion indirectly, as opposed to direct evidence, which explicitly establishes a point. While it does not directly link a person to a crime or event, it provides a framework from which reasonable inferences can be drawn. This evidence often relies on the surrounding context, requiring logical connections between the evidence presented and the conclusion sought. Circumstantial evidence plays a vital role in courtrooms, particularly in cases where direct evidence is scarce or unavailable. For instance, it may include forensic findings such as fingerprints at a crime scene, inconsistencies in alibis, or behavior that aligns with the likelihood of a person committing a specific act. Such evidence requires a synthesis of information to form a cohesive narrative. Its strength lies in accumulating and establishing a pattern, making a case more compelling as multiple pieces fit together. Understanding the distinction between direct and circumstantial evidence. Evidence is the judicial process's cornerstone, allowing courts to establish facts and reach just conclusions. In legal contexts, evidence is broadly categorized into direct and circumstantial, each playing a vital role in uncovering the truth. While both types aim to substantiate claims, they differ in how they connect to the facts. Direct evidence directly proves a fact without requiring inference or interpretation. It provides a straightforward link, often involving eyewitness testimony, confessions, or tangible items like video recordings. For example, a witness who observes a crime and recounts the events in court provides direct evidence of what transpired. Because of its explicit nature, direct evidence is often perceived as more compelling. However, its reliability depends heavily on the source's credibility. Circumstantial evidence, on the other hand, requires the trier of fact to infer the existence of a point from a set of established circumstances. This evidence does not explicitly prove a fact, but suggests it through logical reasoning. For instance, if someone is seen running from a crime scene shortly after it occurred, this observation constitutes circumstantial evidence that they might have been involved. While often dismissed as weaker, circumstantial evidence can be just as robust, particularly when multiple pieces collectively point toward a single conclusion.